So onto my introduction. This is an MLG event, Materialist Lawyers Group event. The event is recorded, like I've already said. We have two incredible panelists for you. What to expect. I'll do this brief introduction, and then we'll have two 15-minute speeches from our panelists. We have the Q&A box, which I'll be monitoring. We also have the chat box that I won't be paying as much attention to. But if you post any questions at whatever time during in the Q&A, then I will read them out when it comes time. So I was just reading one of the comments in the chat box there, getting distracted. So some brief plugs. Materialist Lawyers Group is an organization that creates a space for workers in the legal sector to critically interrogate the political and economic function of their legal practice. So essentially, we're lefties discussing the legal sector. If you are on the left and you feel uncomfortable working in the legal sector for political reasons, then we invite you to join us at MLG and you can help us transform it. We intend to bring you many more events like this, and perhaps one on training contracts, which is something I'd be interested in doing. We have a Patreon for our articles, and it's also linked to the podcast that's going on there as well. I'll plug that in a second. You can find a link to the Patreon mainly on the Twitter account, to be honest. You can find it there in the description. We announced a mentoring scheme, and there's going to be an email that goes out after this event to all the people who have attended and bought tickets. There we'll be looking to pair you up with whoever you've asked for, whether that be a solicitor, a barrister, or a legal academic, and then you can go forward with them. Appreciation Society, which I just mentioned, is the podcast. You can find us on Apple Podcasts, Spotify, Spreaker, anywhere you can find a podcast, really. It's been a bit quiet recently, but we're going to start it up again next week or in the next few weeks' time. And then an important plug is Legal Sector Workers United. So this is the branch of the United Voice of the World for legal workers. If you are a legal worker or you intend to become a legal worker, I strongly recommend you join. I'm a committee member, I'm co-founder of it, and I am happy to answer any questions that you may have on the trade union if you want to message me separately. Really open to that. So brief introductions then. I'm Zachary White. I recently finished up as a trainee solicitor, and I'll be starting as a criminal defence solicitor very soon. I'm a police station rep. I'm a caseworker and organiser with Legal Sector Workers United. So I've seen the discriminatory aspects of what we're going to be discussing in our workplaces firsthand. And I've tried to combat some of that stuff through the casework, through legal methods. But ultimately, my view is we need to be organising as well. And that is where the trade union comes in, and that's where events like this comes in, where we have these discussions. So on to our great panelists. Our first speaker is Zina Islam. She is a barrister practicing in London and founder of Youth Inspire. She also runs Redefined Learning for Lawyers, which is an alternative learning platform for lawyers from underrepresented groups. From Zina, we'll hear about the subtle art of getting pupillage when you don't come from the kind of privileged, privately educated, materially well-off, and usually white kind of background with which the bar is typically associated. It is possible to obtain pupillage despite the forces and gatekeepers that institutions of the bar will, by their very nature, deploy against you. You can game their unjust systems, identifying productive contradictions, and turn at least some aspects of the barrister recruitment process against its deliberately exclusionary and elitist function. So that's going to be very exciting to hear about. Secondly, we have Frank McGuinness. He is a practicing barrister, trade union organizer, and co-founder of Materialist Lawyers Group. He will set out the structural account of the bar and its wider function within the system of law designed to perpetuate unequal class relations. Integral to the administration of imperial capitalism, the Bar of England and Wales is the site of shocking levels of violence against people of colour, women and workers. Rather than merely criticising the elitist and discriminatory culture and conduct of many of the bar's individual members, and rather than stopping at a call for more diverse faces in high places, Frank's critique takes aim at the bar's fundamentally capitalist political and economic function. So, without further ado, we're going to start with Zina. I'm going to spotlight her now. Let's just do that. And over to you.
Thanks so much, Zach, for that introduction. And generally for this invitation to speak and putting this event together. There's an absolute distinct lack of having conversations like this at the bar, and they are absolutely necessary. So I'm going to start by telling you all a little bit about my journey to the bar and my experiences now that I am here. I am a British Muslim Bangladeshi woman of colour, born and brought up in Birmingham. My parents came to the UK in the 60s and 70s without completing their formal education in order to provide for their families back home, and also in the hope of giving us, their children, better opportunities. I wanted to be a barrister from a young age, even when I didn't really know what that meant. I think I was motivated by a sense of fairness, and this solidified as I grew up in the background of 9/11 and as I watched the demonisation and politicisation of my faith and community, and the total and utter carnage that has followed from the so-called war against terror. I remember walking home from school that day and somebody spitting the word Taliban at me. Ironically, this almost echoes an incident whilst at the bar where I was told that someone referred to me as jihadi. In those early years, I naively thought that being a lawyer would be my way of defending my faith, community, and challenging injustice. It wasn't until I progressed through my undergraduate at Warwick and then masters at LSE that I began to properly engage with the reality that law is no saviour and in fact is a tool of oppression. And I carried this with me as I entered the profession, and being in practice has concretised this for me. I took a number of the diversity tick boxes: brown, state school educated, low income household, you get the picture. So trying to access a career at the bar was very much like knocking at the door of an elite members club that I did not belong to. The CV part of me, in terms of academic achievement, awards, etc., got me into the club, but the rest of me has very much remained on the outside. In that sense, my experience perhaps is a little unusual in that I did not face the obvious rejection in terms of accessing pupillage. I was made an offer the first time round. But let me be absolutely clear, my entry is not evidence that the bar is meritocratic, because it simply is not. And one of the statistics from the BSB's diversity survey last year revealed a statistic which every time I look at it just makes me feel a little bit sick. And it's that 44 of white graduates with a 2-1 degree and are very competent in the bar course had commenced pupillage, compared to 23% of graduates from BAME backgrounds with exactly the same grades. These issues don't just stop at accessing the profession, it persists throughout. And the bar has a very real problem with race, amongst other things. On the one hand, I've suffered racism, sexism, Islamophobia, and on the other hand, I've been promoted as a poster girl for social mobility and diversity, somehow proof that the bar is open and accessible to all. But in my 7 years at the bar, just some of the experiences that I've had include the following: the standard sexism from robing room comments from other barristers, sexual harassment from people that have been much more senior to me in terms of call. Islamophobia, I've already given you the example of being referred to as a jihadi, but also other comments such as people's only exposure of Muslims being from the South Park American satirical sitcom, and constantly and repeatedly asked about why I don't drink alcohol, why I don't choose to go to a lot of the events, and so on. I've also, in my early years, was picked up a lot on my Birmingham accent, something which I'm pretty proud of, but that would come up a lot. In my early years, particularly in pupillage, I felt as if I was being censored to an extent because I was told to be careful about tweeting about issues that I'm very passionate about, and the example that I was given at the time was about Palestine. I've been mistaken for the transcriber, court staff, anybody but the barrister. And I've been in lots of situations where my views have been ignored until they're championed by barristers who are white, male, and older. These are just a few examples of things that have happened over the years. As a pupil, my challenge was staying true to my values and not selling out to this idea of who I was supposed to be, whilst also trying to play the game to get to where I needed to get to. There's a stark power imbalance in pupillage and in the early years of tenancy, which can make this particularly difficult. Over the years, I've become known kind of in this diversity space by virtue of some of my outreach work. And it's an area that although I feel passionately about the outreach work, I'm not so keen on this diversity and inclusion narrative kind of label. I've withdrawn from events and awards that purport to celebrate and encourage diversity, when in fact they inherently contradict what they stand for. And some of these examples that I've spoken about publicly include, for example, being shortlisted in the UK Bar Chambers Awards last year for a diversity award. You may or may not be aware of these awards, but arguably they're supposedly one of the most prestigious set of awards for barristers. And I was shortlisted in a diversity inclusion category. But the tickets to go to these awards are in excess of £400. And although my chambers offered to pay for me to attend, that wasn't the point. The point for me was the fact that this is yet another example of how these institutions, organisations and things purport to celebrate and care about these issues, but they explicitly exclude the people they're trying to honour and celebrate and those causes. A similar incident happened with a media platform. I was invited to speak alongside the head of the Bar Council and the former chief prosecutor, which obviously I was a little bit chuffed about given I'm relatively junior compared to those two positions. And I was told that I was invited to speak by virtue of my work in diversity space and so on. But hilariously, when they came to promote the event, they missed out my name on the promotional material, but obviously the other two names were on there, so I withdrew. Again, Legal Diversity Awards a few years ago, I was a finalist. But when I asked for a soft drink rather than an alcoholic drink where the table was, filled with free wine and free whatever else, I had to pay for my lemonade. It's just some examples of how the profession tries to grapple with these issues, but just simply does not get it. And I guess me withdrawing are some examples of my way of trying to resist from within. Over the years, I've grown in confidence and conviction, but it does not stop it being a really difficult terrain to navigate and often very isolating and lonely. But this issue is not just about individual experience, it's systemic. And that's why I have a huge issue with the diversity and inclusion narrative. It's very on trend at the moment and apparently everyone cares about it. But getting more diverse faces into the legal profession is not a solution, because what we're not doing is addressing the root of the problem. What we should be doing is asking questions about why the system has been designed the way that it has. A quote from Angela Davis that many of you might be familiar with is, "I have a hard time accepting diversity as a synonym for justice. It's a corporate strategy designed to ensure that the institution functions in the same way that it functioned before, except now that you have some black faces and brown faces. It's a difference that doesn't make a difference." Having more black and brown lawyers and judges will not make this system fairer. We are not going to make any real change through including people who are simply grateful for a seat at the table. All that does is reinforce and legitimize everything that is already wrong. We need to be more than the acceptance of the palatable voice of colour. I'm not interested in nurturing a generation of Preeti Patels coming through. There is a real need to challenge mainstream narratives, to be critical and to question what we are fed through the system without even knowing what we're consuming. Some of these basic mainstream ideas are that the law is good, police are our protectors, prison is for bad people, and we all have the same rights. Quite simply, this is all a lie. There is an inherent contradiction between the emancipatory potential of the law and the lived reality of countless people and communities who are constantly discriminated against and vilified by the state through the law. In this way, the law is a tool for oppression, and we don't have to look too far for examples of the injustices that the law and the legal system create and perpetuate. Some examples include the counter-terrorism framework, the prevent duty, Schedule 7, recent COVID legislation which has disproportionately impacted racially minoritized groups, The fact that there is a massive overrepresentation of BAME communities in the criminal justice system, the persistent criminalisation of Black people, the hostile and violent immigration system. The list is endless, and none of this is an accident. All it does is reflect the prevailing arrangements of power. Who are the subjectors and who are the subjected? Another issue is the institutionalisation of lawyers ourselves. We advocate for people's rights, but only insofar as the law permits, and based on the assumption that the law is right and that the law is good. We do not engage with a wider conversation about the need for systemic and transformational change. There's a reluctance to appear political, which I find ironic and frankly hilarious, because inequality is exactly that, political. Many lawyers are also institutionalized within the profession, upholding systems of power and privilege within chambers, firms, membership organizations, inns of court, and so on. Even when organizations kind of wake up to the fact that they should be doing more. For example, if we think back to the brutal killing of George Floyd, and organizations, chambers, firms, brands were coming out in support of the Black Lives Matter movement with statements of solidarity. But in my view, much of this is hollow and does not reflect any meaningful internal commitment to change. Are you reviewing your internal structures and policies? What are you doing for your Black staff, members, and colleagues? Too often the burden falls on those of us from these racially minoritized backgrounds to champion the much needed work that needs to happen, with very little responsibility of those in power, those in leadership, taking action on these issues. A recent real low point for me on the back of the George Floyd incident was lawyers coming out on Twitter being really offended and talking about the looting rather than the killing of Black people on the street, talking about the legalities of pulling down the Edward Colston statue rather than what that moment symbolised. 7 years on into practice, there's not a day that goes by where I don't question myself. Why am I working within a system I have no faith in? A system that is designed to hurt, subjugate, and otherize people, often my own people, not to mention having to accept that by being a part of it, I too am complicit. I still haven't reconciled these competing positions in my mind, but here I am with you all today. Some advice that I would have for those of you who might be thinking some of these things and trying to access this profession are as follows. There is a need to critically reflect on your role and what you hope your role to be as a lawyer. You need to be prepared to unlearn and challenge mainstream legal education and be willing to honestly examine and interrogate our own norms. We need to understand that the world relates to us all in different ways by virtue of the different privileges that we hold. We need to accept that the legal system is one of the components of the wider system, and we need to question and accept that we have an enabling role within it. We need to challenge how systems and spaces of power and influence have been set up. We need to accept that law is not a saviour and neither are we. Lawyers alone can never achieve social change and neither can governments. There is an absolute role for mass movements, people on the ground, and that's something that needs to be at the forefront. As difficult as things may seem as you try and pursue this journey, I'd always advise to try and act in congruence with your values and don't feel like you have to be somebody else. And understand that yes, in order to get to where you need to get to, you do need to play the game, but there is a way to do this on your own terms and without conforming. And for anybody that might be interested in any particular support around trying to access careers in law, I run a project, as was mentioned in the introduction, called Redefined Learning for Lawyers. And through that, what I'm doing is specifically targeting aspiring lawyers from these underrepresented groups and really changing the way that we do legal events, much like this event here today. It's not about seeing the same panels, the same white male Oxbridge people talking about things and telling you that, yes, you can be a lawyer. Yes, the only barriers are if you don't work hard enough, not selling that kind of rose-tinted dream that anybody can access the law, because that's just not right and it's just not true. So if you're interested in hearing more about doing things differently, whilst also getting the support from lawyers and practitioners, then please do get in touch and I'll put the details of that particular project on the chat. And also just to say that for all of you that have turned up today, you know, as somebody who, like I said, I'm 7 years in, it doesn't necessarily get any easier, but there is an absolute need for people like you who have these values, who have these views, and that are willing and want to come into this profession that drastically needs people like you to really actually call out and challenge and dismantle these structures, because until we have that, we are where we are. So thank you so much. That's all from me.
Thank you very much for that, Zina. Let's move over to Frank now. I'll just spotlight him.
Thanks very much, and thanks everyone for coming, and thanks Zina for that incredibly thought-provoking contribution to this space that we're trying to create. And oh, am I muted?
Yep, you're good.
I was muted, was I? Okay, sorry about that. Yeah, I was just saying thank you to Zina for your contribution to the space that we're trying to create, and thank you everyone else for coming to this event. I want to start my contribution by talking about Paulo Freire. I'd recommend his book, Pedagogy of the Oppressed, to anyone. It's one of the best books that I've yet to encounter. Genuinely transformative stuff, completely changed the way I see a lot of things. And it's a book, it's called Pedagogy of the Oppressed. It's about pedagogy, and pupillage on one view is a pedagogical exercise. And what's so transformative about Freire's approach is that he talks about education not as a commodity, but as a dialogue between equals. And the dialogue is aimed at understanding the problematic nature of reality so that we can transform it together. And so I find that a very helpful heuristic. The simple question, what's your problem, is a very useful, but disarmingly simple, but very useful question. So I'm operating on the assumption that a lot of the people who've come to the event tonight, the answer to that question is that their problem is they're trying to get pupillage. But actually, what I want you to think about during the course of this event, during the course of this contribution to my contribution to this event, is what other ways might we actually answer that question, and how might we answer that question in a more collective way? As far as practical advice on getting pupillage is concerned, there's time in the Q&A afterwards. If you have practical questions, like, the panel are here to answer those questions, and we're happy to do so. And also the mentorship scheme that Zach mentioned, which is going to be announced on Twitter and in a follow-up email, is another way to get practical advice. But tonight, what I'm really doing is attempting to do something different with my limited space. I'm trying to construct a theory of what's wrong with the world in general, how we change it, and how we specifically apply that to practice in the legal sector and practice at the bar. And so that's like really what I'm doing tonight, is I'm attempting to sketch what we call a praxis, right? A unity of theory and practice. So we talk about the theory in this space. We try and ask ourselves the question, what does it mean to be a radical lawyer? What does it mean to use legal practice to try to change a system which is fundamentally hostile to radical politics? And having tried to develop that theory together, the idea is that we might then go into our legal practices and put it into practice. So Freire says that theory without practice is impotent, and practice without theory is blind. And my experience of practice at the bar is that a lot of people with decent radical intentions and even convictions don't have a theory for what it means to be a radical lawyer, and they end up casting around blindly, doing cases that ultimately reproduce deeply violent institutions that they don't agree with. My position, it's important to mention, is I'm a practicing barrister, I'm a white man, and I have the relative security to say some of these things. And those of us who are on the other side of pupillage don't enjoy that luxury to anywhere near the same extent. And that's something that we have to grapple with. But I also think it's important for people who do have the security of things like tenancy to try to create space for people to have this conversation. That's what we're here trying to do tonight. 3 core messages that I want you to take away from this. Firstly, we have a choice when we're approaching the bar, approaching legal practice. Do we want to be liberal in our approach or radical in our approach? There is, of course, a third option, which is conservatism, but I'm not really going to spend any time talking about that. Broadly, what we mean there is that there is a class conflict. I'm going to get into this. There's a class conflict between labor and capital, and it animates global history. There's other classes that relate to it, but broadly, the central class conflict is between the people who own the means of production and the mass of humanity whom they exploit. And that class conflict creates your positions. If you're for capital, you're a conservative. If you're for the international working class, you're a radical. And if you're for managing that conflict but never really resolving it, you're a liberal. No, the bar is dominated by liberal approaches to everything. This idea that we can sort of like, that the system is inherently fair and you just need to tweak it and manage the conflict between labor and capital. And so what, again, we're here trying to do is to try to encourage people to think about the possibility of actually adopting a radical approach, to take the plunge and move away from this idea that we should like perpetually manage the status quo and actually call for a radical transformation in the interests of the international working class. That's the first message, right? Liberal versus radical. I'm encouraging you to consider adopting a radical approach, as scary as that may seem. The second is, when approaching the bar, should we sort of hide our convictions in order to assimilate, or should we come to the bar in pursuit of class war, waging class war on behalf of the international working class? And in particular, under that second thing, I want to encourage you to think about how meritocracy and social mobility, these ideas, are deeply conservative concepts. They're designed to defend a system of class exploitation and to justify movement between those two classes, rather than abolishing the class distinction itself and creating a classless society. And the third thing, again, on the practical side, the message I want to emphasize is join the trade union, join Legal Sector Workers United, the branch of UVW. That is a trade union. It's where workers go to organize. If you conceptualize of yourself as a worker fighting alongside the international working class, you need to join the union. And secondly, join this mentorship scheme. And together we can have a dialogue of equals about the problematic nature of reality, but the bar in particular. So before I jump into my analysis, which is divided into kind of understanding the world system, the British political economy, the bar, and then individuals' role within that. So 4 different layers. I'm going to go from the very general to the very specific. It's worth mentioning that there is a liberal defense of the existing status quo. There's a liberal defense of the bar, and it revolves around, as I've said, meritocracy and social mobility. Liberals say that the bar has been moving in a progressive direction recently, that there have been more diverse faces in high places, and that's cause for celebration. There's this liberal idea that we should be seeking gradual change towards a more fair system. And crucially, liberals would say that this event is misconceived, that it's not the bar's fault, that we should blame Parliament. If we don't like these oppressive institutions like the Home Office or the British Army, then we can go to Parliament and seek political change there. And it's an interesting point, and it's something that we have to grapple with. Why criticize the violence of the bar when really all the bar is doing is implementing legal norms determined by Parliament? I don't have space within this talk to talk about a full critique of the liberal conceptions of the Constitution, but suffice it to say that it's a very effective defense of the bar. You know, it's not our fault. We're just doing what Parliament told us to do. So let me start then talking about the world system. World systems theory obviously comes to us from thinkers like Emanuel Wallerstein. Really, my characterization of the world system for the purpose of this talk, I can only be very brief. It's characterized by 2 things: capitalism and imperialism. And those 2 things lead to racism, sexism, classism, exploitation, all kinds of violent, unequal phenomena, right? Capitalism, forgive me for going back to basics, capitalism is a system which revolves around, more than anything else, the wage relation, right? So it's about the mass of humanity get sucked into the proletariat, where they have to sell their labor power for a wage, right? In layperson's terms, it just means that workers do work, and any value that they generate by doing work that doesn't return to them in the form of a wage is so-called surplus value, and capitalists get rich by extracting that surplus value. That's the long and short of it. And as I've said, that central class conflict animates global history. It is the central class conflict animating global history. The second characteristic is imperialism, right? Imperialism really is about exploitation, but applied to relations between nations. So just as bosses exploit workers, so too so-called core nations, which have vast accumulations of capital, go around the world and imperialize, violently attack peripheral nations. So we can know imperialism by things like the fact that it's child sweatshop workers in Bangladesh who make clothes for the working class in Britain, and not the other way around. That's imperialism. But also the war in Iraq is a much more violent iteration of imperialism. It's some countries have incredibly powerful militaries, which they use to violently administer an unequal system of class relations between nations, where some countries are required to do certain kinds of labor. And as I've said, capitalism and imperialism leads to racism, sexism, classism, and exploitation. So moving down from the world system then to the British political economy, I think starting point is everyone who can should go and read Nadine El-Anani's book, Bordering Britain, very useful intervention on kind of immigration law and understanding the British political economy. And what's so central about that book is that she's talking about the way in which Britain went from being an empire which ruled over subjects, right? People in India were subjects of the British Empire. And then by the Immigration Act 1971 and the British Nationality Act 1981, it pivoted towards almost like pretending that it was a nation all along. And suddenly there's this British nation. And so the violent spoils of empire are kind of, the people who come from the empire are excluded from the violent spoils, right? From all of the exploitation that I was talking about earlier, right? Accumulates in Britain and people are excluded from it, right? So the reason you need to think about the British political economy is you need to think about what happens in the political economy, because that's going to inform how we understand the function that the bar plays in regulating that political economy, right? So in addition to the racism I've just identified and those two acts, I'm going to talk about some other acts as well. The emphasis will be on acts of parliament, even though that's not a strictly Marxist approach. And that's because I think that will help you to think about how these things I'm talking about connect to practice at the bar, right? These are the acts that you're going to be administering if you become barrister, but these are the acts that you're already administering if you work in any kind of part of the economy, right? You're going to be affected by these legislative regimes. Central to the British political economy is exploitation that I've already discussed, right? That exploitation of the bourgeoisie of the working class by the bourgeoisie leads to material inequality. The most recent manifestation of this, perhaps the most important, like seismic, systemic manifestation of this was the miners' strike, the defeat of the organized institutions of the working class by the violent armed institutions of the British state. And that was in the mid 80s, and it was consolidated in the Trade Union Labour Relations Consolidation Act 1992. That consolidated a new set of class relations pursuant to which workers find it still to this day very, very hard to go on strike. Because of course, withdrawing our labour power has always been the most powerful weapon that we as workers can wield. And so by the 92 Act, the British state intervenes within the contract of employment, and it intervenes in relations between bosses and workers, siding with capital, siding with the bosses. I've already talked about racism. I didn't really talk about the British Army, but that's another violent institution. Unlike immigration, the British bar, the Bar of England and Wales has almost nothing to say about the operation of the British Army. There's some attempts through things like Al-Skini, these cases to extend the Human Rights Act. But broadly, the English bar has almost nothing to say about the operation of British imperialism abroad. And you see that with the discourse around Iraq and Afghanistan and so on, but you also see it recently around the discourse around the IRA, around Irish republicanism, and those who would say that Britain's imperialism is somehow in the past need to contend with the fact that Britain still occupies 6 counties of Ireland, where I come from, and the discourse, Keir Starmer's performance in PMQs, like trying to throw the IRA under the bus, is just absolutely disgusting. Like the idea that the British Empire is in a position to judge the IRA is just absurd. It's absurdly counterintuitive. And yet this is the kind of thinking that you will encounter when you come to the bar. I've not really talked about sexism too much, but broadly we need to understand that in terms of women being brought into the British workforce during the Second World War. That was a really seismic event. That's about capital seeking to proletarianize people. So that's point number 1 on sexism. And number 2, you need to think about reproductive labor. The care labor that's usually unremunerated. It usually takes place in the home. How can you understand sexism without understanding these seismic systemic realities? And we come back to radical versus liberal. The liberal has no real historical account of that. The liberal points to the Equality Act. They point to like an individualized understanding of racism, but it doesn't help us to confront, racism, sexism, classism in their systemic. It doesn't help us to understand the systemic causes of these things. So coming then from the British scale, the scale of the British political economy, such as it is, and I've explained how that's a fiction. Really, it remains an imperial economy. But the fiction of the British national economy, constitutional fiction, we come down to the Bar of England and Wales. Now, my central point here is that, as people who want to be barristers, if you're serious about radical politics, if you're serious about becoming a barrister in pursuit of a radical agenda, you have to understand that the struggle against racism, sexism, and classism at the bar is not about having working class brown women at the bar. That may be part of it, but that is a liberal approach. Obama was the president of the United States. and the United States still bombed weddings in Yemen, right? Like there's these, you see these memes of like people running from a drone strike saying, oh, they say, the next US president is going to be a woman or whatever. It's like, if our account is so vapid that all we care about is putting people with the right identity at the top of these highly violent institutions that discriminate on a worldwide scale, then we may as well just go home. That's not radical politics, it's liberal politics. It's an apology for the status quo, right? So my real takeaway at this level of the bar in England and Wales is that we need to understand its function in administering racist, classist, oppressive systems, right? And centrally, we need to understand its function in administering exploitation and the wage relation, right? I don't want to weigh down my talk with too much theory, so I'll just mention in passing the French philosopher Louis Althusser, whose concept of repressive state apparatuses versus ideological state apparatuses is really helpful here. I've not properly teed up my thinking on this, but broadly, it's interesting to think how, you have these, ACAB's been on Twitter a lot recently because there was that comrade who tweeted ACAB, and now people are trying to say that, if you're in the Labour Party, you shouldn't be calling for the abolition of the police. The police is a very obvious example of a repressive state apparatus. I think the bar fulfills an interesting function. A lot of its violence takes place at the level of ideology. So it's people saying things like, where's the violence? The answer is that it's the bailiff kicking someone out of their house. It's the Home Office, and Serco employed thugs dragging people onto planes to return them to ex-British colonies. That's the violence of law. But when you're in the courtroom, it can seem very sanitized. And it's interesting to think through theories of state apparatuses and how they work at the level of ideology. It's also important when thinking about the bar of England and Wales to think about the amount of damage that's already been done by the time people like yourself applying for pupillage have made it this far. So much of the discrimination that characterizes British imperial capitalism has already had its effect. So that, imagine the difference between an Eton-educated white guy who manages to make it as far as having completed a university education and is applying for pupillage, compared to the Iraqi kid whose school was bombed by a British plane and who never even gets to go to school, let alone come to Britain, right? So it's like there's these world systems that don't even enter the equation when we're asking, from a liberal standpoint, how do we make the pupillage application more fair? And it's like, well, did the Iraqi kid, was applying a meritocratic frame, did the Iraqi kid whose school was bombed and who may be dead, or whose parents may have been killed by all this imperial violence, did they lack merit? Is it their lack of merit that prevented them from ascending to the heights of the British imperial economy? Or is it that when a liberal encounters that, their immediate response is going to be, oh, he's from Iraq, why would he come to the British bar? The obvious response to which is, why did the British state bomb his country, right? So it's like, the violence only goes one way, the thinking only goes one way. We don't think about how much damage has already been done by the time you get to applying for pupillage. If you've made it this far, you're basically fine. That's a really important point. I'm not denigrating the struggle that you all face in attempting to get pupillage, but if you've made it this far, compared to that, we need context. We need to have an imperial context. We need to keep at the forefront of our mind that there are people in seriously dire situations who need our solidarity, and that's what it means to be a radical lawyer. I said I'd not lean too heavily on theory. The one theory, I'm away from London at the moment, so I don't have my bookshelf credibility, so I'm flying a bit blind, but one of the books that I did bring with me that when I was reading it, it occurred to me that was very relevant to this talk. It's from a brilliant book, which I'd encourage you all to read, called Normal Life, Administrative Violence, Critical Trans-Politics and the Limits of Law by Dean Spade. Now I'm reading this excerpt because I think it encourages us to think of racism in structural terms, okay? He says as follows: the ongoing trend away from taxing wealth and towards taxing income from work has continued to build and maintain this wealth into the contemporary period, just as immigration enforcement, mass incarceration, and attacks on workers' rights, public benefits, public transportation, and public education have continued to keep people of colour disproportionately in poverty. To limit our inquiry about why the racial wealth divide exists in the United States today to a search for individual racist employers or bankers suggests that besides these few bad apples, the economy is racially fair or neutral. Such framing is often accompanied by an assertion that people of colour are to blame for their disproportionate poverty. It is often accompanied by the observation that some people of colour do experience financial upward mobility, which, it is asserted, must mean that racism does not mediate economic participation. This logic relies on the individual/intentional model of racism and functions to obscure the true conditions and operations of power that produce a correlation between wealth, race, and lifespan. It is only when we look at purportedly race-neutral population-level methods of control and distribution that we can understand and account for the racial wealth divide, rather than permitting it to be justified through racism, end quote. Now, I suppose what really speaks to me about that is that I think the bar is part of this purportedly race-neutral population-level method of control. The legal system is all about administering class conflict, administering ownership, property, status, legal status, right to be in the country. It's presented as this neutral thing, but it's not. The institution itself is deeply implicated in violently reproducing an unjust society. So if we're going to join that institution, we need to have a clear theory that that is what the institution is. Otherwise, we'll just get lost. So I turn then to the individual level. This perhaps is where I can be permitted a bit more of a personal account, so talk about some of the kind of anecdotes or whatever. But I really don't want to get bogged down in that. I mean, I'm a white guy, I'm Irish, and I have radical politics. And let me tell you, being an Irish Republican at the English bar is not fun. There's a lot of like idiotic British people who don't know anything about my country's history and their empire's violent role in traumatizing it. The fact that we're speaking English and not Irish is a function of the fact that the language that is spoken, the language in which the Irish history was written, was violently attacked by British colonialism. And a lot of these people are completely unaware of that. The last 2 weeks in particular, the discourse has been all about, the IRA and how Keir Starmer apparently prosecuted people in Northern Ireland and all the rest of it. It's just disgusting. It makes me want to scream with rage. How dare the British Empire judge Irish Republicans on the question of unlawful violence? As I'm fond of saying, a judge at and apologies to people who've heard this anecdote more times than they need to, but when I was doing pupillage, a judge sat next to me at one of these boozy pupillage away weekends, said like, oh, Corbyn will never be elected because he's an IRA sympathizer. And I said, what's wrong with sympathizing with the IRA? And he said, they're murderers. So I responded by saying, well, perhaps you can explain how many hundreds of thousands of Iraqis the IRA are responsible for murdering. I'm not here to defend the IRA uncritically. I'm not here to defend the civilians who died at the IRA's hands and IRA bombs. But the idea that the British establishment can lecture the Irish on the question of unlawful violence is absurd. And yet that's the kind of thing you can expect from a judge at the bar, just like a nonsensical account of the British Empire. On a personal level, and this is where I get to the slightly more practical advice to people applying for pupillage, I really think you have to stop caring what the British establishment thinks of you. If you have radical politics, if you're working class, if you come from like so-called non-traditional backgrounds, the bar as an institution despises you. It doesn't want you there. The bar exists to administer those social cleavages. So why would it want to acknowledge people who have come to dismantle those systems, okay? So the bar is fundamentally hostile to you, and it will try to make you think that you're worthless. And if you internalize the bar's way of thinking, then you will internalize that and you will feel worthless. So I think the key is that, the first time I applied for pupillage, I didn't really get anywhere. I was dealing with some really difficult personal stuff, and I think I had still internalized to an extent the idea that I should try and impress the bar. The second time around, I'd stopped caring. I'd realized that I had these like prior political convictions, that I was committed to fighting the class war, to intervening alongside as an organic part of the international working class. And I didn't care if the British bar, the English bar, gave me a job or not, because it didn't matter what they said to me. I was going to keep fighting that class war. And I think, honestly, on a practical level, that registered in a level of confidence, self-confidence, that accounts for the reason that I got pupillage. There are other things, and I'm not trying to be overly self-involved, but I genuinely think my subjective experience of those pupillage and my tenancy interviews was one of being like, give me the job or don't give me the job. I don't care. I'm going to keep fighting these systems, whether you give me the job or not. And that, like I said, registers in a level of confidence that can help you to get the job. I think we should also think about Gramsci on organic intellectuals. Again, I don't want to weigh us down in theory, but basically, do you conceive of yourself as some kind of professional who helps people? Or do you see yourself as a part of the international working class, as an intellectual organic to that class, who participates in the class conflict as it transpires in courts in order to better understand the kind of knowledge that we need to confront those institutions and to disseminate that knowledge amid the wider class? I was in two minds about whether to include this final quote. It is a shocking quote, and it comes with a hefty content warning, okay? So the quote contains a reference to rape. And it comes from a book by Tarek Bakoni called Hamas Contained from 2018. It's at Stanford University Press. And now, the reason I'm conflicted is because it is shocking. The quote is shocking. It's one of the most shocking things I've read, honestly. But I think it provides us with context. And it brings me back to this question about problems. Like, what is the problem we're trying to solve? If all we're doing is trying to get a socially prestigious job at the bar, if that is our problem, is getting pupillage, then fair enough. But you're at the wrong event, because this event is about overcoming the problems posed by global imperial capitalism. And so the reason I'm taking us to Gaza, which is an ex-British colony, right, administered under the so-called British Mandate, and which is now violently administered by Zionist imperialism and apartheid, is that it does put things in perspective. And, you know, I've represented clients from Gaza. I have friends in Gaza. There are 2 million people in an open-air prison. Their problem is that they're in an open-air prison that's routinely bombed by an ethno-state that judges them for the crime of not being Jewish, right? That's a fucking problem. And that's not to minimize the problems that people looking for pupillage face. And indeed, some people will have come from Palestine to see pupillage, right? So there's no neat dichotomy. But that's why I'm including this quote. I feel the need to preface it with that hefty caveat. And so the quote goes as follows. My fixer in Gaza told me a story. There was once a village whose men were all drafted to fight in some faraway battle. While the men were gone, enemy soldiers invaded the village and raped all the women who had been left behind and went on their way. The women, shell-shocked and bloodied, mourned their fate as they congregated to comfort one another in the village square. One woman was missing. They went looking for her and found her lying under the soldier who had tried to rape her. With her own hands, she had managed to kill him and save herself from the lot of her fellow villagers. Joy at her safety soon soured. The raped women now worried they would be judged by their husbands for not similarly fighting for their honor and fending off their rapists. In no time, this undefiled survivor became a symbol of their shame, and swiftly they conspired to kill her. The storyteller turned to me and said, that woman, the survivor, is Gaza. Now, I'm sorry I do this. I inject this really unacceptable level of emotionality, which the bar has taught me not to do. You're not supposed to feel things as deeply as we on the left feel things. And you're not supposed to put that motivation, that anger, at the core of what you do. And that is what is so challenging and scary about the idea of transitioning into radical politics, is that you set yourself against the system and the emotion, but the motivation structure and the desire that unleashes is truly terrifying to the liberals who would defend the system as it is. So the reason that I've shared that incredibly emotional and shocking quote, the reason I've returned us to Gaza to think about people who have serious problems in which the British Empire and the Israeli Empire is complicit, is because we have a choice. We can choose to be the woman from the story who would spit in the face of those who try to dominate us. Now, all of this comes with a hefty caveat, right? Like, if you want to mention your IRA sympathies in your pupillage application, like, good luck to you. Like, you have to play the game. We all do. There is no pure space from which we can retreat to criticize imperial capitalism. We are stuck within inside it, and our critique must be imminent. It must be within the system, the belly of the beast that we're trying to overcome. So it's, as I've said, this was an attempt to construct a theory, but I understand that many of you will have far more practical questions. I just think that we need to establish a proper theory of what we're doing before we can meaningfully talk about the idea of a materialist lawyer, of having a radical legal praxis. So I'll just conclude by reiterating the 3 messages that I was encouraging you to kind of take away from this. Number 1 is you have a choice about whether to be liberal or radical, and it can be scary, and it has consequences if you choose to be a radical, but that is what I'm inviting you to choose to be. Secondly, you can choose to hide your political convictions, even though you be radical. You can choose to hide them with a view to trying to assimilate within a system that you don't really agree with, or you can wage war on that system. The war is already waging, the class war is already waging. you can pick a side. You can choose not to be a liberal and to manage the conflict, but you can choose the side of the international working class. You know, and finally, on the practical side, the third thing is join the union. If you're a worker, you join the trade union and you organize with your class, and join this mentorship scheme so that we can continue to expand this space, and talk about what it means to be a radical lawyer. Thanks very much.
Thank you very much to Zina and Frank. Incredibly incisive and very moving talks that we've just had there, and very thought-provoking. I'm sure we're going to have a really great discussion now off the back of that. We've got a number of questions in the Q&A box. Now is the time to chuck them in. I'll go through them we had one during Zinat's talk as well. So we'll start there. So the first is, as a left-wing activist, and also just to say thank you everybody for coming along as well. We've got a really good turnout. There's 56 people who are here right now. Obviously this is recorded, so this will go up on YouTube or wherever. So lots more people will see it as well. Feel free to tweet about it and share when we send a link to this video, share that around as well. So the first question, maybe I can see both the panelists right now. So maybe if you just raise your hand if you're interested in answering this question, I'll go to you. As a left-wing activist who tweets a lot, what advice do you have about social media etiquette? I want to be able to share my opinions, but I'm worried this will impact pupillage applications and progression at the bar. Any takers on that one? To our two panelists.
Zina, do you want to go first?
Yeah, sure. So I've got two responses to that. The first one is, who the heck cares, do what you want? And that's my instinctual response. But I recognize that comes from also a position of privilege, because I'm in a position where I can tweet what I want to an extent. So I can only tell you the approach that I took, and the approach that I took was that when I was told in Pupillage, for example, to stop tweeting about things like Palestine, I absolutely did not stop tweeting about Palestine, but that was a choice that I made, and that choice potentially can come with consequences. But it's right to say that potentially, depending on what you are tweeting and the causes that you are passionate about, you know, it might create issues for you, and that's just the truth of it, because the system is what it is. So I don't really know if that answers your question, to be honest, and it probably doesn't. But Frank, I don't know if you've got anything you want to add on that, because I know that you're quite a free tweeter as well.
Yeah, I think I basically agree with what you said, Zina. You should tweet. Like, a lot of this operates at the level of like what Foucault called governmentality. I think, like, we think we're not allowed to do things that we actually are. Like, I regularly talk about the IRA on Twitter. I talk about Palestine on Twitter. I talk about Israeli apartheid. Like, what's actually to stop me? The answer is the BSB. So in theory, you can cross a certain line. The main line that seems to exist in a lot of barristers' heads that makes them very anxious is this stuff about bring the bar into disrepute. I would love for someone to try and drag me before my regulator, accusing me of bringing the bar into disrepute for saying that faced with the conflict between the IRA and the British Imperial Army, the choice is absolutely clear. And that's not an uncritical endorsement of the IRA violence, but it's to say that the British Empire is in no position to lecture the Irish on the question of unlawful violence. So yeah, you have to be aware that you are regulated. As a pupil, I think, again, we're back to playing the game. I think that it sucks, but you have to make a calculation about, like, look, if you make it to being a tenant, you will have a lot of freedom. Beforehand, there is a risk that people will use the depth and nature of your political convictions as expressed on Twitter against you. Everyone has to make their own call on that. I think it's part of the problem is that we self-censor in this way, and then we don't talk about Israeli apartheid. We don't talk about British imperialism. We don't talk about the bar being racist and all this kind of stuff because we're worried about the consequences. But ultimately, I guess, again, we're here trying to actually push out the boundaries of what is possible to say. I do think it's important to be considerate. I don't think you should say things just to provoke or to shock. I think you should say things because they're correct and because they help to advance people's understanding of the class war, and because they help to advance people's understanding of what's wrong with society. So I guess the short answer is, like, I'd encourage you to try and have the courage of your convictions and to have those convictions publicly. And ultimately, I think people will respect you for it. But you do have to be careful, and there's no two ways about it.
Cheers for that. Those answers. Next question is, as socialists, is sometimes acceptable or even necessary to advocate the breaking of the rule of law to achieve systemic transformation? How can barristers advocate the necessary breaking of the rule of law, and would this endanger one's job? Any takers?
We can do reverse order if you want. Two things that occurred to me. I suppose the first is the defense of necessity is an interesting one. It's kind of a bit of a bolt hole for barristers, isn't it? You'll have seen that some comrades have occupied Elbit Systems factory, I think, for the last 2 days in protest at Israeli war crimes, or just Israeli apartheid in general, and the way in which the arms trade is implicated in the administration of Israeli colonialism. That is relevant because some of you will be familiar with the case. I think it's from 2009 or 2007 of EDO, which was some comrades who smashed up a arms factory in, I think it was 2009. I think it was during Operation Cast Lead, whenever Israel was bombing Gaza. They smashed up an arms factory and said that they that doing so was necessary to prevent ongoing war crime. Of course, the Goldstone report was later to show that war crimes were taking place in Gaza. And that defense was put to a Brighton jury, and they were acquitted on the basis of necessity. They were acquitted of the charge of criminal damage because they said it was necessary. Now, that was the high watermark of necessity, and I think there's been some rowing back. But I think, again, if what you think is right, like if you want to say that certain laws are unjust, there are ways that you can defend yourself against criticisms that you're preaching, something illegal. You can say, well, actually, if what I'm saying is that you should break laws when it is necessary to do so, there's nothing illegal about that. The law's clear that if it's necessary, you can do that. Admittedly, necessity is very narrowly drawn. So again, you have to be careful about what you say. But also, ultimately, I guess you need to think about revolutionary versus pre-revolutionary situations. Like, we're not currently in a revolutionary situation in this country. So what's to be achieved by arguing for kind of like individualistic, kind of anarchistic acts of law breaking? If it's done in some kind of coordinated way, it's when it's part of the mass movement of the international working class that pushing up against laws becomes viable. And XR are doing interesting things in this regard. I have my critique of XR, but ultimately, I think they're doing some really useful stuff in trying to get people to push up against the limits of legality by saying, well, look, the system is always going to try and prevent you from radically changing it. And if you're serious about changing it, you have to change the law. But perhaps the more left-wing example, because I think XR has pretty ambiguous politics and it's coming out with some pretty anti-political nonsense that I don't have a lot of time for. But the far more pressing and interesting example, I think, is, again, the miners' strike. They were held to be in contempt of court because there was as I understand it, there were injunctions that were preventing them from picketing and stuff and going on strike. And they just went, well, we're going to go on strike anyway. We're going to defy the court and we're going to fight the militarized police service. The response was to sequester the union's assets. Seamus Milne writes about this in his book, The Enemy Within. And the National Union of Mine Workers responded by dealing in cash. Like, that's how far you can go when you're backed by the mass institutions of working class power. You can say, we're going on strike. The court can say, that's illegal. We will sequester your assets if you do that. And the union can respond, do it. You're not going to stop us. You're not going to stop us withdrawing our labor power. You can't. So again, Seema, like you got to be careful about saying, oh, we should break the law. Like, I mean, don't go around saying that, or you will get in trouble with your colleagues at the bar. But if you're careful about what you say, then we can participate in a discourse that's geared towards a serious transformation of existing class relations.
Great. And Zina, do you want to come in on that one? The next question is for you specifically. So
no, I think I'm good on that, actually.
Okay. So just So for Zina, what did playing the game involve for you, and how did you balance this with staying true to your principles?
Yeah, it's a good question. I think for me, in terms of some of the examples that I gave when I was talking about some of the stuff that happened during Pupillage and the way that I dealt with it. So for example, when I was told to stop tweeting in a particular way, I think it's about how you respond. So how I responded as a pupil was different to how I would respond now, not that the actual outcome was any different. So as I said, I didn't stop tweeting in the way that I wanted to tweet, but when I responded to this person who was suggesting it to me, I dealt with that probably in a way of being like, okay, I hear what you're saying, I'll take that on board, but I don't really agree. But if that was me now and somebody was trying to have that conversation with me, the response from me would be very different. So I think it's really about how you respond to the people that you're having to interact with, bearing in mind kind of the end goal. And I guess the other example for me was how all of these kind of social events were all at pubs and bars and whatnot. And in my first 6, there was this whole thing about me being perceived as being too quiet, which is hilarious for anybody that knows me, but whatever. Too quiet because I didn't want to go around drinking and things like that. And that's not an environment I'm comfortable in. But rather than doing what I know some people feel they have to do, which is go to these events, start drinking alcohol, stay out however long, all night and whatever, to try and socialise with solicitors, I'd perhaps every now and again go and show my face for half an hour, have my lemonade, say hello, and then leave. And I guess it was about trying to find ways of doing things on my own terms. But again, how I would respond now to that is I just don't go and I tell them why I'm not going. And I think that the way that these socials are constructed are exclusive and frankly just pointless. So I think it's about trying to figure out what your bottom line is and then figuring out how you respond to that while still not compromising on the kind of end goal, if that makes sense. So it's just in how I have responded, but people respond to these challenges differently. Some people, as I've said, feel like they do have to dress a particular way or change certain things about themselves. And I'm not saying that I blame people for feeling like they've got to do that, because it can be a difficult system. Well, it is a difficult system and profession to be in. Like I know people that changed what they wear and just even stupid things. Like I remember being told, you know, are you going to take your nose stud out for interviews? Are you going to dye your hair back to black? Because at the time it was quite like red, or just all these stupid things that, and I made a choice not to, but I'm very well aware of people that feel like they do have to do those things. And it's what we were saying earlier on, just trying to have the courage and confidence in your own convictions, and then finding a middle ground that will allow you to get into pupillage, finish pupillage, and then when you get past that finish line, you've kind of got that freedom to make those changes from within, as cliche as that sounds, but you'll be in a position to tell people, well, the way that you recruit is stupid, the way that you do socials is stupid, but you need to be there in order to be able to do that.
Thank you very much for that answer, Zina. Okay, so I think we should aim to wrap up at 8:30. So let's kind of do a quick fire round. Let's gun through some of these questions that are really good, and I think they should be addressed. We should try and get them addressed. So this is a long question from our anonymous attendee. I'm not sure if you've seen the issues occurring with the BSB, but a lot of aspiring barristers who are speaking out against the BSB's unfair exam regulations are persons from underrepresented backgrounds. Should those of us already disadvantaged due to our race, gender, nationality, etc., stop speaking out against these things in case they are held against us when applying for pupillages? Anybody? Frank?
I would say, I can only speak for myself. My impression was that a lot of the fairly senior barristers were very sympathetic to the plight of these BSB, of these students, this year taking the bar course. And don't underestimate the extent to which people expect you to be fearless. I mean, you have a core duty to be fearless. And I think having the guts to speak publicly, challenging an institution of power, is a good look for pupillage, to be honest. It's difficult for me to say because hindsight is 2020, but if I was doing pupillage interviews this year, I'd be minded to mention it. If I was in any way involved in that campaign, that Sabre campaign, if I was in any way thinking through the Equality Act implications, the contract law implications of the way in which those exams have been run, then it's a pretty good look for a barrister to say, I was doing the exams, this discriminatory thing happened, I understood it to be illegal in various ways, I participated in a campaign which had not only a legal understanding of the problem, but also a political understanding of it. Certainly at some chambers, that's going to be impressive. As far as your conduct on Twitter, I think Barrister Twitter, as insufferable as Barrister Twitter often is actually with you on this one. So I wouldn't be too worried about tweeting about it. Again, with the caveat, like, look, it's social media. You can ruin your career by saying something wrong. Don't say something, certainly don't say something that's oppressive. But if all you're doing is challenging the BSB, who by all accounts have completely messed it up this year, with devastating consequences for people who struggled to get as far as they have, of course, as a collective, we should be pointing out how unfair that is. And I think you should think seriously about raising your voice and saying as an individual how it's personally affected you, but also how it's affected the cohort this year. So again, I have to give you equivocal answers every time because it's like everyone has to make their own choices on this. But I think you have to ask yourself, at what point should you be allowed to say what you actually think? Why would you want to join a profession where you're not allowed to say what you actually think for fear of being punished? And I don't know if it's directly relevant. I'm conscious that the question's about the BSB exams. But I remember when I was applying to be a pupil, one of the key things that motivated me was wanting to prosecute Israeli war criminals. And I spoke to this woman who's a friend of a friend, and she sort of worked at a large bank as in-house counsel. She was helping me do like my, it wasn't pupillage yet, it was scholarship to do the bar course. And she was like, oh, don't mention the Palestine stuff. I think she's wrong. I think people respect you when you say something true. Whenever you say, well, this is the real reason why I'm here. And I think that applies to confronting the BSB. You can pretend everything's okay or you know, stay silent. Or maybe you can say, this is an outrage. This is absolutely outrageous, the way the BSB has handled this. It's had all of these discriminatory effects. So equivocal response as usual, but I'd encourage people to speak up. I think that you're okay on this one.
Okay, gonna need quicker answers. Zina, would you like to come in on this one?
No, just agree with that. And again, there's loads of support in the kind of profession in relation to this. So I don't think that you would have any issues with saying it as it is.
Awesome. So this one's from Declan to Frank. Can you allude to the problematic nature of the monarchy as it relates to the bar and republicanism?
Yeah, so, well, it's slightly ridiculous, isn't it? Like, monarchy is not even capitalist, it's a feudal institution. It comes to us from a time whenever the constitution was governed by the notion that the monarch was God's representative on earth, and that he or she owned all of the land and had, like, you know, feudal lords who then parceled out the land and had serfs who were tied to their lords, right? It's an expressly feudal institution. Kudos to the British Constitution for being so versatile that it's been able to transition into capitalism without shedding these feudal vestiges. Obviously, it poses issues for Irish republicanism. One of the key sticking points with Sinn Féin MPs is they won't take their seats because they're not prepared to swear an oath of allegiance to the Queen. But really, that's window dressing. It's not that they're not prepared to swear an oath of allegiance to the Queen as a person. It's that they don't recognise the legitimacy of British imperial sovereignty in the 6 counties, and so it's an abstentionist strategy which I don't doubt they would continue to employ even if Britain tomorrow voted to abolish the monarchy. So I guess my answer is that I think we can get a bit stuck on it. Connolly has that great quote about the flag flying over Dublin Castle. If we change the flag flying over Dublin Castle from the British flag to a green flag, the English will still rule you. And I think that's true to a large extent of the monarchy. I think that it's mostly superficial, and our critique should be of the capitalist class, not of the monarchy. But at the same time, clearly it's a deeply reactionary institution. Clearly she does control like billions of pounds worth of land and property and all the rest of it. We should be for abolishing the monarchy, but I don't think it's a particularly pressing demand. And as a matter of constitutional law, I actually think, you know, the Queen in Parliament, where the Parliament is directly elected, is a better model for a constitution than what you have in the US, where they have no monarchy, but they have an unelected Supreme Court, sorry, an elected Supreme Court technically, but like a Supreme Court that can completely ride roughshod over the popular will. So it's an important issue. Symbolism matters. It also has a material impact. But as far as the cause of Irish republicanism is concerned, I don't think the monarchy is the main thing we should be focusing on right now. Brexit is the main thing we should be focusing on right now. Brexit is what promises to bring about a united Ireland, because the idiots in the British establishment forgot that they had an enduring colony in the country where you and I grew up, Declan. And it's the imperial chickens coming home to roost. So I'm not sure the monarchy is the right focus, but it's certainly, like, obviously the Queen shouldn't exist. It's a ridiculous feudal institution and we should be in favor of abolishing it. I'm just not sure it's the most urgent political demand.
Okay. Could you give some practical advice and examples on how to play the game in pupillage interviews in a way that doesn't betray our values and convictions? Also, how important is it to get pupillage in a radical progressive chambers? There are only a handful of those at best, and competition is fierce. Zina?
I think I've already kind of answered the first part of it, so I'll answer the second part. I guess my first question would be, are there really any chambers that are truly radical? Question mark. It's a theoretical conversation. I know that outwardly there are certain chambers that are certainly perceived that way. Whether that is true in reality, I'm not entirely sure. I personally am not at a set which I think would identify itself as radical, but the reality is that as a self-employed barrister, your identity as a lawyer is very much your own, and it's about how you shape your practice, what your politics are, what your interests are, what projects you get involved in. So I don't think being at a set necessarily inhibits that. Obviously, there might be some considerations to think about, such as, you know, I ended up at a criminal defence set. I've never done any prosecution work, and that is aligned with my values, but I recognise that, you know, some people have to accept pupillage at the CPS or do prosecution work and whatever else. So it's that whole thing again of getting to where you need to get to, but just remembering who you are and what you want to do, and then carving out your practice based on that, and then remembering that if you need to jump ship later on, you can do that. But I would put a question mark, and I think Frank would be better placed to answer this bit, because I do think that there are chambers that have these reputations, but are they truly that way? I don't know.
Yeah, I totally agree. And this isn't really meant to be particularly critical of the bar. It's just, again, it's meant to be critical in the sense of like trying to understand what the bar actually is. I think there are some radical solicitors firms. I think Bernberg Pierce in particular is an example of an actually radical set. Some places like the Public Interest Law Centre as well, Commons Legal, like, you know, a workers' cooperative law firm. These are law firms that are attempting to actually walk the walk and do radical stuff, like, and it registers at the level of the way that they organize their practices. But something about the institution of self-employment really cuts against radicalism. And there are various chambers that have tried to do it over the years, have tried to become radical, but they tend to get co-opted by liberal forces. And again, I mean that not particularly as a criticism, but again, coming back to my definition of liberal versus radical, who can point to the chambers that proudly says on its masthead, like, we're for the workers against capital? Like, we are fighting the international class war against the bourgeoisie. Like, that's radical. That's not me being like a kind of like chest thumping Marxist or something. That's just the definition of radical. So who is openly saying that? Who is saying that's what we're doing? And even if they're not saying it openly, who in practice is actually doing that? I'm not clear. I'm not aware of any chambers that's really succeeded in doing that, or even come close, to be honest. And I don't think they want to. And maybe we can ask ourselves why that is, and maybe we can ask ourselves whether it is too contradictory. So radical chambers, question whether they exist. Is it possible to have a radical practice? Yes, it definitely is. And I totally agree with what Zinat said about, you know, as a self-employed barrister, you are surprisingly free to do your own practice. I mean, this is the other side of pupillage, but whenever I got made a tenant, you know, I got some innocuous email from marketing saying, oh, do you want to draft your profile? It's like, they just go like, okay, right, draft your profile. It's your profile. It's not like there's some line manager saying you can't say that. So there actually is, paradoxically, there's a lot of freedom that comes from tenancy. But when you're the other side of pupillage, when you're trying to get pupillage, I think getting pupillage in the more left liberal sets will definitely help you to organize with people and to encounter people who share your values. But you're always going to be in liberal institutions at the bar. You're always going to be in institutions that are hostile to your radical politics. And so you need to go into that with your eyes open. As for the first part of the question, then, I'm sorry, the concise answer to the second part of the question is get pupillage wherever you can get it. Pupillage is pupillage, and then once you have a practicing certificate, you can do what you want. That's really vital. And you can also transfer to different chambers after you've got cold. So there's two approaches. There's spearfishing and there's dragnet. Some people apply to lots and lots of places, dragnet approach. Other people spearfish, they go, I want to be there, there, or there, and they apply. I applied to 5 chambers. I know plenty of people who applied to 30. So matter for you really, both approaches can get the goods. And for the first part of the question, playing the game in pupillage interviews, honestly, so I only did pupillage interviews at One Pump Court and Garden Court. And in both of those cases, it wasn't political at all. I was surprised by how unpolitical it was and actually relieved by how unpolitical it was. It does actually test your ability as a barrister. It's stuff like a plea and mitigation. It's stuff like answering questions about, I remember answering a question in a pupillage interview about evidence from a foreign jurisdiction. What'd you do with that? I remember having to analyze a Supreme Court judgment and answer the question, did the judges get the law right? Where's the politics in that? Like, it is super liberal. It's about administering law. And ultimately, there is a technical skill to administering law that isn't particularly amenable to political analysis. So ultimately, like, I wouldn't be too worried about being too political in pupillage interviews, because there's not that much space for it, to be honest. But then again, I guess my other thing that I would say is that, like, it's worth considering whether being honest is actually what gets you the goods. They'll go, oh, wow, that was really memorable when you said, well, actually, I'm really interested in international criminal law and I want to prosecute war criminals. Like, yeah, fair play. Like, he obviously meant that when he gave that answer to that question. And maybe that will actually help you to stand out. Again, equivocal answer. You sort of have to learn how to play the game. Everyone learns how to play the game themselves. But ultimately, I do think honesty is probably the best policy.
Thank you. So Finian's question, which is, I think, linked to what we've just been discussing. So related to the question of the rule of law, my question is about the cab rank rule. The traditional justification, is that the bar is independent and individual barristers lack the legitimacy to pick and choose which laws are good and bad. How, as radical lawyers, can we go about thinking about this and ultimately challenging it with clerks, clients, and other barristers? Zina?
I think I might pass on this because I've been in a long-standing case for 3.5 years, so Frank might be better placed.
Yeah, I just have never encountered it in practice. I think partly that's because I'm a Garden Court, so like we don't act for landlords, we don't prosecute, don't act for employers. We don't do that much employment, but when we do it, we only act for claimants. We don't act for the Home Office, so it's never really been an issue. I think it's more of a crime thing. I think if you're in criminal practice, crime is such a cluster, especially towards the more junior end, where it's like, you have 5 hearings a week, sometimes 3 hearings a day. And I don't know how the clerks do it. It's really impressive. And I think probably the cab rank rule, more than anything, is a historical attempt to help the clerks to force people to accept briefs. Whereas when you're doing a civil practice, which is a much more civil pace, if you'll pardon the pun, it tends to be that, like, someone comes to you with a case, you're just like, oh no, I'm planning to be on a holiday then, or I'm doing paperwork that week. Like, no one's going to force you to do a case that you don't want at a set like mine. And I question whether in practice no one has ever tapped the cab rank rule at me in whatever 4 years of practice. I've never encountered that. But maybe at more kind of centrist, like common law sets, it's a thing. Like, maybe the clerks are coming and saying, no, you have to accept this brief because I can see that your diary's free. I question whether they'd be able to enforce it. But I guess the short answer again is, like, if someone tries to make you do a case that you don't want to do for political reasons, I would just not do it. And well, if it came to me, I would just talk publicly about it as well. And if the BSB wanted to hold me before my regulator, like I'd probably just take the point and just say this rule is ridiculous. Like, everyone's like, and then I would cite evidence about how many people are violating it, and then I just use that as a pretext for saying that the rule is stupid and doesn't really apply anymore.
Thanks. So we may have covered this one already, but I'll throw it out there, and if there's anything to add, then that'll be great. So, as a South Asian Muslim woman, I think it is much harder to be vocal about your radical politics in comparison to white people. So in a way, we will have to hide our politics when applying for pupillages. As ethnic minorities have a harder time in gaining pupillages, how does one counter this?
Yeah, firstly, I totally agree with you. So as an example, I think if I were to speak out publicly and say the stuff that Frank, for example, has said in relation to Palestine and Israel, as he has today, I would get, I think, a very different response. And I've seen that play out in other conversations with other colleagues, where when it's been a white person or a non-Muslim person speak out about BDS or Israel or Gaza, the response has been very different. So just to say, yes, I agree with you and you're absolutely right. It is different in terms of the fact, of hiding your politics. I think we've covered this already in our responses earlier on. It's very much just dependent on what sits well with you and what you feel able to do, and making that decision, and just remembering that obviously pupillage is a starting point, and then thereafter comes the freedom to determine how you want to move forward. But again, it's a difficult one. I don't know whether Frank's got anything else to say in relation to that.
Yeah, I think the key thing that I would say is that you should join the union, because the starting point is just, it's much more difficult for people of color, for women, for Muslims to speak out, and part of the way around that is to try to collectivize the systems that are oppressing you. And so joining the union is a really good way of doing that. I organize alongside, a formidable number of formidable people of color, a number of Muslim women. The union organizes around issues to do with immigration detention and housing, and it provides us with this pretext for collectivizing our voice. But also, I think sometimes when you're in a subordinate position, whenever you are being oppressed because of your identity, it can be helpful to have safe spaces where you can talk about these things and say, look, should I say something about this? Should I tweet something about this? Should we release a statement about this? I really believe that the only meaningful and satisfying response to racism and sexism and classism, Islamophobia, all the rest of it, disability discrimination, has to be a collective response. And I think that response starts in the trade union. The trade union is a safe space. It's a place where you can go to talk about the way in which you're oppressed. And I think that's part of the answer to your problem. But again, the starting point remains, we live in an incredibly racist, sexist, capitalist society that's going to make it difficult for people with excluded or marginalized identities from speaking up. But we're here in this event to try to encourage people to do just that, to have the courage to be like, I know that I'm going to get more shit from this than a white guy is, but I'm going to say it anyway because someone has to. And then if enough of us do that, we will actually start to change the system.
So the next question, I think similarly can be answered. So a quite individual question. I have not been getting jobs specifically because if you Google my name, my BDS campaigning comes up and some inaccurate news articles about me from websites such as Israeli Hate News. Sorry. I was thinking of using a different surname when applying to pupillages. Would you recommend this? That sounds like a casework issue. I would recommend joining the union and then just getting advice directly from the casework team, because we've dealt with stuff to do with the SRA mostly at the moment. We haven't dealt with the BSB as much, but that's definitely something we'd be keen to sink our teeth into at LSWU. Any views from the panel?
I mean, there's evidence, isn't there, that when you anonymize names in job applications, that people with non-white sounding names are more likely to get jobs. So the discrimination is palpable. Discrimination around Palestinian advocacy is also palpable. I guess it's worth considering, but it's pretty outrageous that you've had to do that just for speaking up in defense of Palestine. I mean, I don't know what you said, but obviously, if all you've done is to express support for Palestinians against the apartheid colonial regime that's oppressing them, then it's an outrage that you've been denied work that way. Arguably contrary to the Equality Act. You'd have to show. I mean, you'd have to have a fight in court about it, but it's arguably unlawful discrimination.
So how has your in of court helped you throughout your career? What made you pick your in, and what role do ins play in your theoretical understanding of the bar? And so we've got 4 minutes left. So I don't know, maybe this will be the last one. We'll see what these answers are like.
My in helped me because it gave me lots of money. So it gave me a scholarship to do the BPTC. Without the scholarship, wouldn't have been able to do the bar. I got a scholarship to do a fellowship abroad. So I guess for me, the answer is financial. I personally haven't been that engaged with my in or feel like I've received anything in particular beyond that. Not, yeah, I mean, maybe that's me not being proactive or whatever. And you have the qualifying sessions. I pretty much hated them all. And it was very much a tick box thing that I had to do. But yeah, I'm at Inner Temple, I should have said. And I should say that the reason I joined is because I was told that they were the most progressive, whatever that means. And also they serve halal meat at the qualifying session. So that's why I joined.
Yeah, I don't think about my in very much at all. Again, as with Zeenat, they gave me a scholarship. Lincoln's Inn, I think they don't have means tested scholarships, which is really annoying. So it meant that the scholarship didn't even cover the fees of the course. It was back when I did it was 17k, I think, for the bar course, and they gave me 15k, and it was a bit like, okay, cool. How am I supposed to live? And I think some of the other inns do means tested scholarships. That I think would be the main criteria on which I would have chosen if I'd known. Like I was just an idiot. I was like, I don't know what I'm doing, and no one seemed to have any real advice on what inn to choose. And the main purpose of the inn is to give you a scholarship to do the bar course. Like the qualifying sessions, like as Zeenat said, are ridiculous, feudal nonsense. Like in defense of them, they're supposed to try and like socialize you into the bar, but the problem with that is that the bar is like a horrible place. And so if you think it's a horrible place, you're going to find those sessions horrible because they're trying to change you into some kind of idiot, like white Eton Oxbridge guy that you don't want to be. When you're this side of pupillage, it's probably quite important to think carefully about how to get a scholarship and stuff. But post pupillage, the inn just doesn't play that much of a role in my life. Really nice library. Yeah, some cool scholarships for like Pegasus scholarships, whatever that you can maybe look into. But inns aren't a massive part of the picture to my mind.
Let me unmute myself. Great. So I think we've had an incredible event tonight, and there's lots of very good questions that have gone unanswered as yet. And I've also seen one from Jerome a little bit earlier on as well. What I'd say with all these questions, can you just copy and paste them out? I'm going to drop our email address in the chat from Notorious Lawyers Group. And then you could just send it to us. I'll make sure it gets to Zeenat and Frank, and maybe say who you want to answer those questions, or maybe from both of them we want their views. There's also been a discussion there about people who are saying, look, I've really enjoyed this conversation, and if there's lots of like-minded people who share these views, then I want to stay in touch with them. That's great. So off the top of my head, I think we should probably just have another event where it's not a panel event. We just have a Zoom discussion, and we'll send the link out. So there's two things that come out after this. The mentorship scheme that we're going to be setting up. So you'll be alerted about that. And if you want to be a part of that, great stuff. And then secondly, I think we should have another discussion where lots of people can contribute, just an open discussion. And then maybe we can have breakout groups, that sort of thing. I alluded to it at the beginning, but I'd love to do the same thing, but to do with like the training contract route and to do with the SRA. I think it's a slightly different playing field, but you know, there's lots of similarities going on there. Again, thank you very much to the two panelists. It's been a really incredible discussion. I think a lot of people have a lot to take away from this right now. And I hope some people who have maybe felt more isolated before no longer feel that way. And I hope they stay in touch with us as we sort of build this movement and we transform the legal sector ourselves. From Notorious Lawyers Group, the union has come about, and we're trying to create lots of other institutions as well that's going to have material change on stuff. So it's all really exciting. There's a lot of energy, and I look forward to meeting you. I'm sure the two panelists look forward to meeting you all as well. Any last thoughts from the panelists?
I want to leave the last word to Zeenat, so I'll go first and just say, yeah, echo what you said about thanking everyone who came, and just saying, join the union. Like the single most radical thing you can do if you want to be a radical lawyer is join LSWU. And I wish it had been around when I was trying to become a pupil, because what it will do is it will plug you into a network of hundreds of people across the legal sector. And it's also a members-led union. So if there are specific issues that are pissing you off, even to do with the pupillage process itself, we have a pupillage working group where you can come to discuss these issues, talk about all of these issues, but instead of feeling like an isolated individual, to actually be part of a movement that has the power to change things. So yeah, thanks everyone for coming, and make sure that if you haven't already that you join LSWE.
Yeah, just to echo what everyone said, thank you all for coming, and especially to you guys as attendees. Like I said, I'm 7 years into this, and you know, each and every day I feel isolated and lonely in this profession, but knowing that there are so many people interested in getting involved in this particular space from this particular angle really gives me hope for the future. So thank you all.
Wonderful. So let's wrap up then. Thanks for coming, everybody. And yeah, you'll be hearing from us very soon. So keep an eye on your emails. Goodbye for now.